Tēnā koutou katoa, ngā mihi nui o te ahi ko Jessie Lapthorne hau. Welcome everybody, special welcome to everybody who could make it here in person and also to those of you dialing in online. One of the benefits of COVID, I think, is that we can offer this live stream session to our clients remotely. Those in Australia and further afield and also within New Zealand are able to join us and have this update too. So that's cool. Just a couple of housekeeping matters before we get started for those in the room. If we need to evacuate, there is an exit immediately across the hall there from the doors that you entered. Just follow one of the team who hopefully you've already met and will assemble down in the square below. We will take questions at the end just to help us run to time. And for those of you dialing in online, feel free to type them into the chat box. And we've got Caitlin from our team who will go through those at the end. We'll try to get through as many of them as we can. But if we don't manage to, we'll come back to you directly. And afterwards, if there's anything that we haven't managed to touch on that anybody here wants to speak to us about, then you're welcome to hang around afterwards. A few of us will be here to talk to afterwards. So yeah, so that's the main intro piece. Today we've got two of our fantastic senior associates who are going to take us through some of this changing landscape of employment law, ever changing as it may be. There's quite a lot to get through, so I won't hold things up anymore, but I'll hand over to Helen Pryde and Jeremy Ansell to take you through it. Thank you.
Thanks, Jessie. Thanks everyone for turning up today. We really appreciate you making the effort to come in person. It's the first time the firm's done an event like this in I think a couple of years, 2.5 years, so really appreciate it. I was just going to do a quick précis of the topics that we're going to discuss. So Helen's going to start us off by talking about the Holidays Act task force and the potential changes coming to the Holidays Act legislation. I'll then cover the new proposed income protection insurance scheme and the implications that might have for employers. Helen's then going to talk about the distinction between contractors and employees and some upcoming changes in that area. I'll then cover the Fair Pay Agreement Bill, which is currently working its way through Parliament, and some of the changes that we're likely to see there very, very soon. And then we're both going to touch on the hybrid working arrangements topics.
So looking first of all at the Holidays Act and the reasons for change. As many of you will be aware, the current legislation is often criticised and generally regarded as being outdated and overly complex. A number of specific issues have also arisen. For example, employers have significant difficulty in correctly calculating holiday pay under the Act. As of 2021, payroll audits by the Labour Inspectorate had resulted in just under $250 million being paid out to employees as a result of those issues. There's also a need for greater clarity regarding some of the language. One example in particular relates to Section 14 and the definition of gross earnings. And some of you will be aware of the Metro Glass case that has dealt with that problem. And in addition, the framework for bereavement leave is obsolete, and there are also issues, thanks Michaela, with the way that other leave becomes available. I'll just move on to that slide. There we go. So further to these and other issues, the Holidays Act task force was established, and that was made up of representatives from the government, Council of Trade Unions and Business New Zealand, and that was established in 2018. The purpose being to review the Act and consider its application for the first time, in fact, since 2003, when it first came into force, and then to provide recommendations for reform. So the task force report in 2019 made 22 recommendations, and almost a year and a half ago in February 2021, the government confirmed that all of those recommendations would be accepted. Some of the issues considered have already become law, including the increase in sick leave to 10 days, and also the introduction of a Matariki public holiday. That wasn't in fact a task force recommendation, but it was an election promise nonetheless. The government has said it's expected to introduce legislation into Parliament in mid-2022, but clearly that's now been and gone. So It's not apparent exactly when it's going to happen, but certainly it's expected sometime soon. And whenever it does get there, after its first reading in Parliament, it will be examined by a select committee, and then the public will be able to make submissions, which will be considered by the committee before the findings and recommendations are shared with Parliament. The Ministry of Business, Innovation and Employment has also indicated that there will be a transition phase before any new legislation becomes effective. And of course, until any new legislation does come into effect, all of the existing rules still apply. So what can we expect from the new legislation? Well, first of all, in respect of annual leave, based on the task force recommendations, employees would continue to become entitled to 4 weeks leave after 12 months of continuous employment. So that's the present position. However, the proposal is to allow employees to take leave in advance on an accrual pro rata basis. And of course, that reflects the policy that a lot of businesses already have, but it isn't currently a requirement. So under the recommendations, that would become the case. Annual holiday entitlements would also be calculated, taken, paid and held in weeks or portions of weeks. And this means that payroll systems will need to be able to show proportions of weeks, so presumably either in fractions or decimals. When considering this proposal, the task force did specifically recognise that the calculation of annual holiday entitlements is one of the most significant difficulties facing employers under the current Holidays Act. And that's particularly the case where employees have varied hours of work or varied rates of pay. And this is especially the case when it comes to figuring out what a working week is for the purpose of calculating entitlements. So to assist in addressing the difficulty of the annual leave calculation, the task force has also recommended a new concept of ordinary leave pay, or OLP. And this is intended to replace the current relevant daily pay and ordinary weekly pay calculations. OLP, as is shown on the slide, would include a base rate for any hours worked in the relevant period, plus pay for any scheduled overtime, allowances, incentive or commission payments that the employee would have received if they had worked during the relevant period. Payment of annual leave would then be based on the greater of three calculations, being OLP, average weekly earnings over the last 13 weeks, or average weekly earnings over the last 52 weeks. Currently, sick leave, family violence and bereavement leave accrue after 6 months continuous employment. This will change under the task force recommendations so that bereavement leave and family violence leave become available from the first day, and sick leave will also begin to accrue from the first day. Employees will also be entitled to take that leave in units of less than a day, beginning with a minimum of a quarter of a day. And again, although that is something that some employers currently do allow, it isn't currently an entitlement. A new methodology for calculating family violence leave, bereavement leave, alternative holidays, public holidays and sick leave, also known as FBATS leave, has also been proposed. The task force recommended a prescriptive test to identify if the day concerned is an otherwise working day. And this is based on whether the employee was expected to work according to a work pattern that was previously agreed. So that would mean based on regular shifts or a typical roster or the employment agreement. Or if the employee has worked on 50% or more of the corresponding days in either the previous 4 weeks or the previous 13 weeks. Relevant hours are then determined by the hours set out in the employment agreement or roster. And if this isn't possible, the expected hours of work should be calculated by average hours across all corresponding days worked in the previous 13 weeks. So for example, if the day in question is a Monday, then it would be the average hours worked on all Mondays over the previous 13 weeks. Following this, average daily pay is calculated, and this is based on the hourly rate, which is earnings divided by hours over the last 13 weeks. The employer then pays the greater of the average daily pay or ordinary leave pay, OLP, which was the new concept that I described in relation to annual leave on the last slide. Given that the task force made 22 recommendations, there are obviously quite a few other changes proposed. The principal ones to be aware of are shown on the slide. First of all, gross earnings. Essentially, all cash payments, including discretionary bonuses, etc., are included in gross earnings across a 52-week period. So the result of this will be that, an additional payment of 8% on top of the original bonus amount. And that, of course, means that employers may need to consider reducing bonus entitlements to account for potential double dipping. Pay-as-you-go holiday pay will also be affected. There'll be tighter rules around casuals and a requirement to review their status every 13 weeks. The ability to pay pay-as-you-go holiday pay to employees on fixed term agreements of less than 12 months will also be removed. Then there is the parental leave override. Employers returning from parental leave will have leave calculated in the usual way, rather than defaulting to a 52-week average calculation. And among other issues, the view that the task force expressed in relation to this was that it will help address discriminatory practices used against parents who need to take time off to care for a dependent child. In relation to bereavement leave, this will take into account a modern understanding of family, and employees will be able to access bereavement leave following the loss of someone outside of their immediate family group, so including aunts, uncles, step-parents, stepchildren, nieces, nephews, etc., and basically bringing that part of the legislation up to date with the reality of modern life. A lot of employers have, again, recognised the need for flexibility in this area for a long time. So many policies have allowed for a wider view, but again, it isn't currently a legislative entitlement. In relation to close down, the rule in Metro Glass requiring employees in the first 12 months of service to have holiday pay paid out at the beginning of a close down period will be overridden. This has caused a lot of confusion, so no doubt will be a relief to a lot of employers who've had to deal with that issue. And then finally, the final recommended change to note relates to the sale and transfer of a business, following which employees will have the choice to transfer leave to the new employer or have it paid out. So that's all on the Holidays Act for now. I'm going to hand you over to Jeremy, who will tell you all about the proposed income insurance scheme.
Thanks, Helen. So yeah, my first topic's the New Zealand Income Insurance Scheme. Important to note from the outset that this is just a proposal. There's no firm law on this. The starting position is that in New Zealand there's no compulsory income insurance for employees. There are a range of providers out there who offer policies on income protection insurance, and many people choose to avail themselves of that opportunity. However, no compulsion at the moment. So where we got to was in February 2022, there was a document that was released by the Minister of Finance, the New Zealand Council of Trade Unions and Business New Zealand, and they discussed the possibility of having a compulsory income protection insurance scheme. And the consultation document talks about some of the drivers behind the change and what they're trying to achieve out of it. So some of the concerns were that in the case of people who are made redundant through no fault of their own, there's often a lack of redundancy compensation provisions in many employment agreements. When people are made redundant through no fault of their own, they often struggle to find an analogous position straight away, or they may feel pressured to take something that doesn't quite fit their skill set. And there was also discussion about the role of technology and automation and how that might result in a lot of roles, a lot of people being made redundant because simply the functions that they were performing are now being taken over by technology. In the case of people who have illnesses or sickness, there was discussion in the document about how many people often feel pressured to stay in their jobs, even when they have an illness. Of course, we're talking about illnesses here. We're not talking about injuries, which are already covered by the ACC scheme. So the overall aim is to address people who lose their jobs through no fault of their own, i.e. in the case of redundancy, or are unable to work because of a illness or a sickness. So who would be eligible for the scheme if it goes ahead? So New Zealand residents and citizens would be eligible. You would need to have worked in New Zealand or have been on paid parental leave for 6 out of the last 18 months. The intention is to cover fixed term and seasonal workers at this stage. And there's discussion about whether the scheme would possibly expand to include contractors and self-employed people. That's unclear at this stage. People who have multiple jobs would also be eligible for the scheme if they were to, in the case of redundancy, lose a job that provided up to 20% of their income. So what support would be available under this scheme? So in the event of somebody losing their job due to a redundancy or being unable to work due to a illness or a sickness, they would qualify for 80% of their normal salary or wages, capped up to that level on the screen, $130,911 for salaries. Employers, in the case of redundancy, who were proposing to terminate an employee after a restructure would have to give 4 weeks notice. The same employer would then be required to pay 80% of the employee's normal wages or salary for that first 1 month period. The employee would then be eligible to receive a further 6 months of income protection payments under the scheme. The 6 months is a maximum, so if they were to find work within that period, they certainly wouldn't qualify for the full 6 months. Claimants would only be allowed to receive 6 months of insurance payments every 18 months, and the payments received under the scheme would be considered income and would be taxed in the normal manner. So a couple of specific criteria in relation to employees made redundant. The scheme as it is currently proposed says that the job must actually end. It's not sufficient for the employee to just have their hours reduced. They must actually be terminated on the grounds of redundancy. In the case of illness or sickness, for somebody to be granted cover, they must have to stop working entirely or experience a reduction in their work capacity by at least 50%, and the health condition or the disability would need to last for more than 4 weeks. So any health issues that last for fewer than 4 weeks would be addressed via the existing mechanisms, sick leave, etc. So the example that was given in the consultation document about the scheme in respect of illness or sickness was, for example, somebody who is diagnosed with cancer. They're unable to work. They then have to go and have chemotherapy treatment. They're not captured by the ACC scheme because it's not an injury, but under this scheme, they would have cover until hopefully they're at a point where they're able to return to work. So what obligations would claimants have to receive these payments? In the case of redundancy, they'd have to be searching for work or preparing to search for work. They'd be required to accept any job offer that matches their previous income, skills and terms of conditions. It is possible for people to be in approved training or rehabilitation programs while continuing to receive the payments. Claimants would need to remain in New Zealand, so you couldn't be claiming these income protection payments and be on holiday overseas at the same time. And payments would of course be stopped were the claimants not to be complying with their obligations in any way. So how would all of this be funded? It would be covered by employers and employees. So as it's currently proposed, the scheme would result in employers and employees paying contributions at the rate of 1.39% of an employee's salary or wage. So it would operate similar to how the ACC scheme currently operates with these levies in place. They're envisaging that the 1.39% contribution rates would be reviewed after 2 years. And to give you an idea of how it stacks up to countries that we normally compare ourselves to, Canada have a compulsory income insurance scheme. The employee contributions are 1.66%, so higher than what's being proposed here. And the employer contributions are much higher than what's being proposed here at 2.32%. UK also have a similar arrangement there. Contribution percentages are much higher, but that includes all forms of social insurance. So in terms of timeframes and where this is at, as I say, a decision is expected soon about whether the government intend to push through with this scheme. There was an article released earlier this morning on the newsroom website saying that, quoting Grant Robertson and saying that they're now suggesting that if the scheme is implemented, it's not going to happen until 2024, which is a change in the original position. The significance of that is that that would be after the next election date, and we know that the National Party and the ACT Party have come out saying they don't agree with the logic and the rationale behind this scheme. So it could become one of those things that disappears into an abyss after the next election, depending on what happens. But what we know that the government have done is they've set up a ACC group to start working on the preparatory work to roll out the income protection insurance scheme. And the rationale behind that is that if ACC have to administer this whole scheme, there's going to be a massive amount of work that's required to be done, and they thought it was wise to start doing some preparatory work. So in terms of the implications, if the scheme comes to fruition, obviously we'll have quite big implications on the private insurance market. So at the moment, people can take out income protection insurance through their own provider. You'd expect to see a drop off in people taking up those types of policies. There might be all of a sudden an increased willingness for individuals to accept redundancies in a restructure, knowing that they could have the fallback option of being on that scheme. There's a possible issue of double dipping from employee claimants potentially. So you could have a situation where, say, a person loses their employment on the grounds of redundancy. They challenge the validity of that redundancy and take a PG, claiming compensation, while at the same time they could be receiving payments, or at least the first month of payments from the insurer, from their employer under that scheme. And then there's the issue of how do you police whether people are actively and genuinely looking for work while they're on that 6-month period. You have to apparently be actively searching for work and show that you're making genuine attempts, but you're going to be relying on ACC to police that, I guess, and show that people are genuinely looking for work. So it'll be interesting to see what happens with it. It's quite a massive shift for us, and we'll see what happens. So hand over to Helen to talk about employees and contractors.
Jeremy. So employees and contractors. It's a topic that many of you may well be familiar with. If not from your own experience, then perhaps from having attended seminars where it's been discussed or debated previously. It's long been a hot issue, and it remains the case. The question of what makes someone an employee is probably the most litigated issue in employment law, has been for some time, and will continue to be, no doubt. And it's been in the news again recently because of a second Uber challenge by unions A2 and First Union, who have been seeking a declaration that Uber drivers are employees. And that follows an earlier claim by a specific individual driver who claimed to be an employee, but in fact was found to be a contractor. So it's a bit of wait and see at the moment to find out what happens in the next 3 months with that decision. But certainly it is the case that this is an issue that can affect any industry, couriers, medical practitioners, interpreters, painters, construction workers, gardeners and salespeople are all roles where misclassification has been argued. And notwithstanding any intention or agreement of the parties, it remains a factual inquiry as things stand today. The relevant legislation says that the real nature of the relationship must be considered, and the factors that you can see on the slide. So the nature of the contract, the parties' intention, where control lies between the parties, the extent of any integration, and the economic reality of the relationship are all matters that will be considered by the court when making that determination. However, the fact that it is such an ongoing issue makes it clear that it's easier said than done for businesses to classify their workers correctly. And it's not necessarily the case that this is a result of ill intention. It's often influenced by industry practices. But this can be high risk for business. And if a worker is found to be an employee after having previously been classified as a contractor, there will be back pay of Holidays Act entitlements to deal with, KiwiSaver, and also if the relationship has soured as a result of the issues arising from the classification, and then there may also be employment grievances to deal with. So this slide shows the information from the Employment Court decision in Leota and Parcel Express Limited. And Leota involved a courier driver who had been engaged as an independent contractor, but argued successfully that he was in fact an employee. And the judgment sets out a list of common indicia, as they were called, that will usually be considered in assessing whether a worker is an employee or a contractor, and the status they point to. And these considerations are shown in full on the slide. So, for example, where a worker is required to wear a uniform, or perhaps display material that associates them with the hirer's business, then this will generally point to them being an employee. In contrast, where a worker is free to work for others at the same time, then that suggests that they are a contractor. But as you'll see, those are just a couple of the considerations that the court took into account in that case. So it had long been expected and discussed by employment lawyers and other interested parties that a third category of workers would be introduced, and generally this has been referred to as dependent contractors. This is something that has happened in some overseas jurisdictions, and these workers are self-employed contractors, although they are effectively under the control of the employer. So, for example, courier driver in the case of Leota that I referred to a moment ago, who was contracted exclusively to one courier company, in the case where a third category of workers exists, could be considered to be a dependent contractor. However, that is all really now academic, because the tripartite working group examining the issue, as you'll see on the slide, has instead recommended that defining a clearer boundary between employment relationships and contractor relationships should be the focus. It has made 7 recommendations, including, first and foremost, a revised legislative definition of employee. And having regard to the indicia in Leota that was shown on the last slide, the TWG report has also referred to 9 design principles used for worker classification. And that will be used as the basis for constructing a more detailed, objective and prescriptive legislative requirements for classifying workers as employees or contractors. And the aim of these principles would be to create an effective legal duty on hiring entities. They would need to go through a robust decision-making process, guided by the legislation, when considering worker classification, and very significantly, the intention is that the hiring entity will be the party responsible for making that decision correctly. Other recommendations by the TWG are further policy work and consultation, the focus of this being to understand the impacts and to manage the risk of any unintended consequences, and also consider how business models could transition away from unlawful classification practices in a way that's fair for all of the people involved. It also proposes the development of a comprehensive package of guidance and support services to support better classification practices by organisations in the first instance. So essentially, on a pragmatic basis, to help businesses to get it right from the start so that these issues don't arise. In addition, the TWG has recommended that judicial determinations on employment status should be allowed to cover other workers performing similar work by the same hiring entity under similar contractual terms, and that's not currently the case, and that's quite a significant change again, because at the moment there has been a lot of litigation on this issue, but it all tends to be quite piecemeal and on a case-by-case basis. But the final and potentially most far-reaching recommendation is that the definition of employee would be aligned across employment and tax legislation. And what the TWG proposes is that this should allow for information sharing between the Inland Revenue and the employment regulator. Also, that the government should explore ways for the tax system to be used as an intervention point to encourage better classification practices. And what this means is, for example, that businesses could be required to notify the Inland Revenue of any decisions that they make in relation to worker classification, and also to provide the legal basis for that decision. It's also possible that penalties could be imposed for taking an unreasonable position in relation to that classification. So this report has only been provided very recently at the end of 2021, and it isn't yet clear when these changes could be introduced. The next step is for the government to develop and publicly consult on a policy proposal based on the TWG's recommendations. In the meantime, some steps employers could take and should take to limit liability are, first of all, as you can see on the slide, to limit exclusive engagement with contractors, to limit rosters and restrictive hours of work where contractors are engaged, and to have clear and concise written agreements that reflect the reality of the working relationship, and to ensure clear termination clauses for fixed and indefinite service agreements. And it's also always worth it for employers to take the time to review their worker engagement practices and consider whether the contractor relationships that they have in place are truly a reflection of the reality, or potentially are they more a reflection of company or industry practice. I'll hand back to Jeremy now, who's going to talk to you about fair pay agreements.
Thanks, Helen. Fair pay agreements, you've possibly seen quite a bit about this in the media at the moment. It's fairly topical. Firstly, to start off, what is a FPA? It's a sector-wide agreement that sets minimum terms and conditions of employment for all employees across a particular industry or occupation. We'll come back to what those two terms mean shortly. So the status quo at the moment is obviously some areas of work are more unionised than others. At the moment, there's several collective employment agreements, which is an agreement negotiated between a union and linked to a specific work site or a specific employer. And there's also several what are called MECA agreements, multi-employer collective agreements between that cover multiple employers in a certain industry. But FPAs would obviously go further and include all workers within a certain industry or an occupation. So how did this come about? It came about as a result of the Labor Party's commitment prior to the 2020 general election. Some of the aims of the regime are to improve wages and conditions for employees in certain industries or occupations that are traditionally lower paid, to level the playing field so that employers who are trying hard to offer fair terms and conditions to employees don't get undercut and disadvantaged by those who are not, and to allow unions and employers to identify critical issues relating to each specific industry or occupation covered by an FPA, and then to try and address those via the agreement, for example, labour shortages. FPAs have been referred to by commentators as the most radical overhaul of New Zealand's employment laws in the last 30 years. So it is significant, and it's coming up fairly quickly. Just to touch on the progress of the legislation, the Fair Pay Agreements Bill was introduced to Parliament in March of this year. It's now past its first reading stage. It's out for select committee, so they've had written submissions. A lot of people submitted on the bill, and they're now receiving oral submissions, and the select committee is due to report back to Parliament in October 2022. It will then go through the normal legislative process. There'll be a second and a third reading. So it's not out of the realms of possibility that FPAs will be in place by the end of 2022 or the beginning of 2023. So how would a union initiate bargaining for a fair pay agreement? So you would have to satisfy one of these two tests. So the first is the representation threshold test. You'd have to show that you have at least 1,000 employees who are going to be covered who support the initiation of bargaining, or 10% of all covered employees, or, and it's an or, not an and, the public interest test is met. I'll just skip forward quickly to talk about the public interest test. So the types of things that would be considered here, if a union wants to satisfy that the public interest test has been met, that it's in the public interest for this sector or industry or occupation to have an FPA, they need to highlight some of these things. For example, that workers traditionally receive low pay for work within that industry or occupation, that workers traditionally have little bargaining power, that the industry is maybe known for exploitation of migrant workers, that there's a lack of pay progression, that workers in that industry traditionally work long and social hours, weekends, nights, etc., etc. So the union needs, when they apply to commence bargaining for an FPA, they'd need to specify which of those two tests they think have been fulfilled, and they would then need to say whether they believe it's going to be an occupation-based FPA or an industry-based FPA. And the examples they give in the Fair Pay Agreements Bill of both are that an occupation-based agreement would, for example, be one that covers all commercial-based cleaners, whereas an industry-based agreement would cover, for example, butchers and bakers within the supermarket or grocery industry. So occupation, I think, is quite easy to find. It's literally every single person who does that particular role. Industry-based is maybe a bit more nebulous. At the moment, contractors are not currently included within the scope of the regime, but there's talk of that potentially happening as well. What would these agreements include? So there would be mandatory terms that must be included within a fair pay agreement. So there'd have to be a coverage clause that would have to detail the hours of work for all employees in that occupation or industry, minimum base wage rates, overtime rates, and the term. And the rule would be that the term has to be between 3 and 5 years. There would be a whole lot of mandatory items, should say items, not terms, that must be discussed but do not necessarily need to be included within the agreement. Things like redundancy provisions, health and safety requirements, flexible working arrangements. Potentially there is scope for regional differences within a fair pay agreement. So for example, a group of supermarket workers are bargaining for a fair pay agreement. Apparently there might be a provision for different pay rates depending on region. So you might have different pay rates for Auckland or Wellington, larger cities, where potentially they can pay workers more, and different rates for the region down south or in a smaller location. In terms of the bargaining process and how this would work, there'd be an employee bargaining side and an employer bargaining side. So the employee bargaining side would primarily be the relevant union. It is possible to join other unions to the proceedings as well. The employer bargaining side would require at least one what's been called employer association. So you may have heard Business New Zealand were originally being touted as the primary employer organisation. They were going to represent the interests of employers who were drawn into FPAs, but they've sort of washed their hands of the whole thing and don't want to be involved. They've cited a whole lot of things they think are wrong with the regime. Kirk Hope, the CEO, referred to the ugly truth behind fair pay agreements, said it was inherently unfair, doesn't like a one-size-fits-all approach. So the problem, as I see it anyway, with the regime at the moment is that you've got the body that was intended to be the main employer association advocating for the interests of employers with FPAs who don't want to be involved. So it's a little unclear who these employer associations are going to be. There would be government financial support. Each side would get $50,000 per bargaining side with additional funds made available. And the intention was for the New Zealand Council of Trade Unions and Business New Zealand to get $250,000 each for their role in supporting FPAs. So essentially what happens is the parties get together, they bargain on terms and conditions that are going to apply to all workers in that occupation or industry. There's no duty to conclude bargaining, but if the parties can't ultimately reach agreement, then the Employment Relations Authority may be called upon to make a determination. There are dispute resolution mechanisms, so if the parties have a dispute over a bargaining issue, they could go to mediation or they could get the Employment Relations Authority involved in that as well. And yeah, obviously it's quite significant if there's no agreement, then you're in the hands of the Employment Relations Authority to set the terms of the agreement. So in terms of how the parties would finalise agreement, an FPA, go back to the supermarket example, you've got the union representing the supermarket workers who have negotiated for several weeks or months or however long. You've got the employer association who's representing the interests of employers in the supermarket industry. They finally get a meeting of the minds, they agree terms. How does it come into force? So it would need to be ratified by both parties. First, before that happens, the Employment Relations Authority would review the agreement and make sure there's nothing in there that's contrary to law. Then it requires a simple majority of employee and employer votes to ratify the agreement. So it's the 50% plus one rule. It can't be 50%, it has to be a majority. And in the case of employers, a covered employer has one vote for each of their employees that is covered by the agreement. So it's all weighted. If the ratification vote fails, the parties are sent back to resume bargaining and they have another crack at it. If a second ratification fails, then the ERA is called upon to set the terms of the fair pay agreement. And it's unclear whether it's necessarily an area that the Employment Relations Authority want to wade into with all the other work they have on. And that diagram, if you can read it, possibly not, it's quite useful to show how you could get involved in almost a circular process if things don't go to plan. So the implications of the regime, obviously the intention is to lift the wage rates of industries and occupations where workers are traditionally underpaid. Most people would see that as a good thing, but in a legal sense, potentially there's an unintended consequence there of expanding the regime beyond lower paid occupations and industries, because if a higher paid occupation or industry can meet that representation threshold test or public interest test, probably less likely to meet public interest, but there's no reason why they couldn't be negotiating for a fair pay agreement as well. There's maybe a concern for smaller employers that they're effectively in the hands of this employer association, somebody who's advocating their interests on their behalf, but they're not actually around the bargaining table to be involved in the discussion. So how effective is the representation? And I guess for smaller employers, they may find themselves bound by these minimum wage rates for their particular sector or occupation, but have fewer resources to be able to afford that. The larger employers The 10% representation threshold seems very low. There's talk in the introductory documents to the bill that could be changed depending on how frequent and commonplace these FPAs become. And the difficulty of defining the public interest test. If a union comes forward and says that they believe they've met the public interest test, but the other side disagrees, that could lead to litigation. So it's certainly coming through the regime, likely by the end of this year, or possibly at the start of next year. So significant change ahead. Hand over to Helen now to cover part one of flexi working.
So managing work from home and hybrid work models, an issue I imagine that many of you are more than familiar with already, because many employers are combining remote and on-site working after lockdowns, and because that showed the potential of remote working as well as more flexibility. And of course, the experience has shown quite a lot of different points of view in terms of pros and cons. That there can be benefits in terms of increased productivity, and also high levels of employee satisfaction, and better work-life balance is often the argument in favour of remote or flexible working. However, of course, there can also be challenges. Leading a team that is physically divided between the office and home can impact on the team dynamic. Recognising and supporting employees who might be struggling with the workload or burnout or mental health, perhaps resulting from being in isolation, or being somewhat isolated by working from home, and the impact of any workload. And then also monitoring productivity without breaking trust is often an issue. But enabling remote and flexible work also involves balancing business considerations and the legal framework. Business considerations, which I will discuss in a moment, will take account of, or does take account of multiple factors. And two very different but related considerations are employee retention and business output. Jeremy will then talk about the legal framework, and that includes obligations in the employment relationship as well as regulatory duties. So looking first of all at the business considerations, the COVID pandemic, of course, threw many businesses in at the deep end when remote working became a necessity in many industries. And this experience has highlighted the key pros and cons, including those that I've already mentioned, some of which can, of course, cut both ways. And this is shown, for example, in respect of employer and employee views in relation to productivity. So following Microsoft's 2022 hybrid work survey, data showed that in New Zealand, 63% of business leaders fear that productivity has been negatively impacted since the shift to remote or hybrid work. In contrast to this, 79% of workers say that they are as productive or even more productive than they were compared to a year ago. So obviously quite different perspectives. Other factors to consider in the pros and cons categories are that high productivity can mask an exhausted workforce. Last year, 51% of workers said that they felt overworked and 45% were exhausted. And that might feel familiar to a lot of people in this room. Particularly workers, though, aged in the 18 to 25 category, 54% of whom said that they were merely surviving or flat out struggling. There's also the issue of shrinking networks that are endangering innovation. 17% of workers experienced decreased interactions with co-workers with the move to remote work. However, a positive feature of remote working, from an employee satisfaction perspective at least, is that employees can be increasingly mobile when remote work is available. More than half of workers surveyed have considered moving to a new location due to remote work options. And that can have obvious upsides for those struggling with the cost of living in Auckland, for example. And the ability to work remotely can therefore mean the availability of a wider pool of potentially more satisfied employees. So rather than taking an either-or view, employers should consider whether a hybrid model of working would be suitable for their business. So, for example, allowing employees to work 2 days at home and 3 days in the office, or some version of that, and perhaps different versions of that for different employees. When making this assessment, the primary factor to take account of would likely be the specific needs of clients and customers, and if these can adequately be met in circumstances where employees are working remotely. And it's always worth a business considering, even if sort of initially at face value, it doesn't seem like something that would work for their business. It may be something that could be factored even just for 1 day a week. So as noted earlier, another relevant consideration will be staff culture and whether this might suffer if employees are permitted to work from home. And potentially the impact that this is going to have on the team dynamic. So again, some employers have considered this and how they can achieve an ongoing positive team dynamic by introducing at least 1 day where everybody has to be in the office. And that's just one example of how you might get around the issue. It's also worth noting that Microsoft found employees have a new worth it equation, and that means what people want from work and what they're willing to give in return. Microsoft noted that the power dynamic is shifting and perks like free food and corner office no longer cut it because people have different values. So notably, 44% of employees are more likely to prioritise health and well-being over work than before the pandemic. And with ongoing talk of the Great Resignation, it will come as no surprise to anyone that 48% of workers are somewhat or extremely likely to consider changing employers this year. So businesses may be unsure whether to trust that staff can work effectively if they are working remotely, and whether that is regular hours or flexible working hours. But in many industries, ultimately, there may be a need to accept this way of working because the availability of remote and flexible working options is likely to be key to staff retention. And on the subject of health and well-being, employers also have the same health and safety obligations under remote and flexible arrangements in the workplace, as Jeremy will explain to you in a moment.
Helen, what are your, as employers, what are your legal rights, I guess, when you have an employee or a group of employees who want to work exclusively from home or predominantly from home? So the starting position is the employment agreement. So the employment agreement will normally stipulate the place of work. It'll say that a certain office or other location is required from time to time, but an employee doesn't have an ability to unilaterally change their place of work. It can, of course, be done by agreement. So if you have an employee who all of a sudden decides they want to work exclusively from home, you can always refer back to the employment agreement as a decent starting point. Employees do have the mechanism to make a formal request for flexible working arrangements. In my experience, it's not something that comes up a massive amount, but it does happen sometimes. And that's provided for under Part 6AA of the Employment Relations Act. So if an employer receives a flexible working request and it's submitted in the correct way, etc., the employer is obliged to consider it and to respond within 1 month, but sooner if possible. And you don't have to accept the request. So the request might be, I want to work 3 days from home per week to cater for my childcare arrangements, whatever. But you don't have to accept it. But what you would have to do would be to genuinely consider it. There are certain grounds in which you can refuse the request. So if you think it might have, for example, a detrimental impact on the quality of the employee's work, if it creates additional costs for you somehow, if it has an effect on the business's ability to meet customer demand, etc., or if it's difficult to reorganise work amongst other staff to accommodate that employee, then those are all genuine reasons to decline. But like anything with employment law, the requirement of good faith is crucially important. So you'd be obliged to genuinely consider the request in good faith and communicate honest and openly with the employee. What health and safety obligations do you have? Well, employers must take reasonably practical steps to protect the health and safety of their employees at work. So how does that work how does that operate when the place of work is essentially somebody's home? Of course, it's a matter of scale. Nobody's suggesting for a second you need to send a person round to ergonomically assess somebody's home office. That's not practical and potentially invasive as well. But what employers should be doing is putting out a list of things that employees should consider within their own home office setup. So for example, if they check that they've got the right table height and the right screen height and the right type of chairs and things like that, do they have a adequate and safe environment in which to work? And then there's also, so that's the physical environment maybe, but then there's also the non-physical side of things. So for employees who are working predominantly or exclusively from home, what steps are you taking as an employer to ensure that they maintain/retain some degree of connection with the workplace and with their manager? Are people checking in on them? Are you having team calls to check on how people are doing if they're in that situation? So that's all important as well. And certainly if an employee does request something for their home working arrangement that might make it a little easier or a little safer for them, the employer should probably give some thought to whether that's something they can agree to. I've seen stories of people, for example, requesting that the employer pays their internet costs because it's now being used predominantly for work purposes. That to me seems ridiculous and a step too far, but there are requests like that coming out as well. In terms of privacy and firstly in terms of monitoring of employees, the employer is certainly required to assess what the employee is doing while they're working from home. So employers are fully entitled to check in and ask for a breakdown or a summary of what the work is being performed. But you obviously wouldn't go to the extent of tracking emails or looking at emails or anything like that. It's all a matter of scale, as I mentioned before. A lot of employers are also concerned about the security and the confidentiality of their information. So if your employees deal with highly sensitive, confidential information, it's always a good idea to have some guidelines as to how they should be dealing with that information in a home office setup. So for example, if they have hard copy documents, that's becoming more and more rare, but if they do, then there should be rules surrounding saying things like don't leave them out and open. I guess the same goes for confidential information that might be on a laptop screen. But it's mainly just making sure that your employees are being careful with any confidential information that they might be referring to or using at home. And that, I guess, extends to phone calls and things like that as well. If you've got employees that live in a flat or a shared living arrangement or something like that, it's always worth mentioning that they might want to make sure they've got some degree of privacy when they're having private client calls. But as Helen sort of alluded to before, it's always a good idea to have you don't necessarily need to have a policy in place governing hybrid working arrangements or working from home arrangements. If you don't want to go that far, you can always just have directions that are issued to staff by way of email or whatever other form of communication, but make sure you continually review them and update them. And if you do decide that you want to have a working from home policy or a hybrid working policy, the types of things you might include in there are notice requirements of, so how much notice does an employee have to give if they intend to work from home? Does it need to be stipulated at the start of the week? Can it be done on a day-to-day basis? Do you have rules that say there's a maximum number of days that employees can work from home? Do you want to rule out having them working from home on Mondays and Fridays for fear that people tack it on and crowd a long weekend for themselves, things like that? And you'd have, as I said, you'd have some rules about security of confidential information and health and safety setup and making sure that their working environment is safe. I think that's all we've got time for So we're happy to take any questions. And if not questions, any thoughts that people have on some of the legislative changes that are up and coming, and fair pay agreements, and income protection insurance, and Holidays Act changes and things like that. If you have any comments on how that might impact on your business, we'd be keen to discuss.
Some online questions.
Yeah, Jeremy, we've got one just on that last topic, so I'll throw that to you first. Is the employer obliged to provide or contribute to the cost of equipment so that staff can work successfully from home? For example, computer screens, keyboard, mouse, as their home setup may be ergonomically less than ideal. I don't know if people at home could hear that question. Summarise.
So the question was, are employers obliged to contribute to the cost of setting up an employee's homework setup, computer screens, etc.? There's no legal obligation to do it, but a lot of employers are choosing to do so. So some may provide a working from home allowance if they think they're going to have a large number of employees that are working from home. It is a bit of a help, because it is, I think a lot of employers would find it maybe difficult to go out and buy all that stuff for themselves. There is a difference between having a proper office set up, isn't there? Proper screens, etc., versus just working off a laptop. So it's really at the discretion of the employer, but many are choosing to do that.
Cool. We actually have one other question online anyway, and this is for you as well, Jeremy. In terms of the income support scheme, the question was, you referred to losing your role through no fault of your own. Would this apply for someone that has been made redundant due to being put through a selection process and then being unsuccessful through that route?
So would they qualify for the scheme? If yes, they would, because it's still termination on the grounds of redundancy. So it wouldn't matter whether there was a selection process and they were unsuccessful, or whether they've just been told that there was no longer a genuine business need for their role. They'd still meet the criteria to be part of that scheme. Any questions from the floor? Sure.
Holiday pay. How you're really reliant on our payroll software. So if we've done everything correctly, our dates are correct, and all the pay has been correct, how covered are they relying on the payroll software to pay out for it?
Well, ultimately the obligation rests with the employer to ensure that its employees are paid according to the Holidays Act legislation. And so what has happened, and sort of as a result of some of the issues that I was referring to at the beginning of my presentation, is that issues have arisen, and employers have then proceeded to undertake reviews based on the way that their payroll has been dealt with historically. And that may be because issues have arisen and been brought to their attention by employees, or it may be that they've been made aware of issues across businesses or across the industry. So usually where employers rather are aware of these issues, or voluntarily conduct a review and voluntarily conduct a remediation process, then we wouldn't expect any further issues to arise from that. So does that answer your question? But the issues really arise when an employer isn't really participating properly and doesn't have proper oversight of its payroll processes and isn't engaged in those. But it can't just sort of delegate that responsibility, although there is certainly some mitigation in terms of using a payroll company to assist in those processes.
So I've got a question on Holidays Act as well. So when the sick leave went from 5 to 10 days, there was also discussion that potentially sick leave would commence from day 0 rather than 6 months in. And I think last time I checked on the government website, they've still got a little bit of info that says we're reviewing that and it will potentially come in early 2022.
Yeah.
Heard nothing more. It wasn't on your presentation. Just wondering where that landed.
So that is the anticipated New Holidays Act legislation. So at the moment, sick leave is available as an entitlement from the 6-month point, but the recommendation by the task force is that it will begin to accrue from the first day of employment. So the way that they put it is, because at the time that they were writing the report, it was on the basis of the 5 days. So the way that they put it is that you would accrue, you'd have a 1 day from day one, and then I think it was over every couple of months you'd accrue a further day until you got to the 6-month point, and then you'd have the 5 days. So I assume obviously now that the 10 days has been introduced, that will be adjusted to reflect that accrual process in a similar way. But yes, the short answer is right now it's after 6 months. If and when that legislation comes through, it's expected to be available to some extent from the first day.
Is that, sorry, does that mirror the Australian way of doing it? Just we're part of an Australian business and our payroll system.
I don't know the answer to that question. I don't know whether somebody else on my team may know.
Sorry.
No.
No, I know they've done a accrual-based process.
Yeah. I can certainly try and find out for you. And let you know.
No, it's all right. I'll wait and see.
My question is about the Holidays Act as well. What's the timeline that we're looking at for implementation?
Well, so they initially said early 2022, and then they said mid 2022, that the first draft of the bill was expected, at which point they're going to go to the select committee. We're now July, nearly August, so we're already way past the midpoint. At the moment, it's not clear. I would expect it to be this year, and that there will be a first draft, but watch the space coming soon, I think, is unfortunately the ambiguous response to your question.
We've got one more online question. Helen, for independent contractor discussions, if an independent contractor is specifically denied the option of subcontracting, does that mean they are then excluded from the definition of being a contractor?
Ah, okay. So if they are wholly responsible for the work under the contract, yeah, and that they're not able to delegate that work to anybody else, well, that is one of the factors. It could be an indication, but it's by itself, it's not a deciding factor. It's just one of the factors that will be taken into consideration. But it's certainly from a business point of view, it's a scenario to be avoided, or at least considered carefully in the context of all of the other factors that the court would take into consideration when making a determination.
So thank you, Helen, Jeremy. It's really useful to shine a light on some of the changes which are coming, and also how to be prepared for that. So for those of you who didn't catch the Cotterill introduction, or those of you online who dialed in just slightly late, belated introduction, I'm Jessie Lapthorne, one of the 3 partners in the Auckland employment team, alongside Mark Lawler and Kirsty McDonald. Kirsty can't be here tonight. But just on behalf of my partners and the whole team, I'd like to say thank you very much for making the effort to come in. It's been fantastic to be able to host in person for the first time in years. So thank you to all of you who could be here, and thank you to all of you who have dialed in online as well. If there's any further questions, just feel free to hang around afterwards or to reach out to your contact, but we'll cut off the live stream now. So thanks very much. And thank you to all of you as well.